But it was just impossible for this to have happened. He's supposed to have in the space of 5 minutes done a couple of very brutal things to the two boys while dressed in his full regalia after Mass. The two choir boys apparently had detached themselves from the choir procession, which after Mass, and had snuck into the sacristy and were having a tipple. Allegedly, Pell came upon them, all vested from Mass, was quite upset with them, and then sexually assaulted them in a most brutal fashion, as described by the anonymous witness. And so he was convicted on the second trial on 5 counts for that particular incident. And then the witness, the complainant rather, alleged that a few months later, or a few weeks later anyway, into 1997, he suddenly he saw this young kid. He's 13 years old at the time, and again assaulted him. The defense lawyer, a very experienced criminal lawyer, sort of went through point by point the allegations and showed, at least to my satisfaction, obviously not to the jury's, it was just impossible for this to have happened. He's supposed to have in the space of 5 minutes done a couple of very brutal things to the two boys while dressed in his full regalia after Mass. Now, if you're a Catholic and you know anything about the way priests dress and the way, an archbishop after a solemn Mass dresses, it's quite awkward, and just to physically actually accomplish what Pell was supposed to have done is improbable. Plus the fact that this sacristy was, as I said, it's very large, it's very open, and it's actually a hive of activity, priests coming and going, altar boys coming and going. The fact that the archbishop, regardless of all this, was able to commit the crime seems highly improbable. Anyhow, he has been convicted, but mind you, this is the second trial that he's been through. The first trial, which heard the same evidence, was a hung jury. It was the vote for the jury was 10-2. Unfortunately, I think in Victoria, the state of Victoria, because we have a federal system here, the state of Victoria, an 11-1 verdict is sufficient to acquit or to convict, to reach a decision. But it was 10-2, so they had another trial. At this trial, they didn't actually summon the witness. They simply used the video proceedings from the first trial. So it's really, I think to a lot of people, it's a mystery how he could possibly have been convicted. And I think that the defense lawyers are going to appeal will use the fact that will question whether the jury could possibly have reached a fair verdict on the basis of such weak evidence.